kind of cases. I hope the screen is visible.
Yeah, it's visible.
Thank you. Thank you. So basically, again, NCLAT, Honorable NCLAT Delhi bench. So this is Pramod Kumar Pathak versus Arfat Petrochemicals Private Limited. So again, the crux basically is you have BIFR, right? So in BIFR, you have rehabilitation schemes. So there was one notification of 2017 from the government, which says it can be considered as a resolution plan. And we'll read on the notification as well. So this application pertains to an aggrieved person saying that the rehabilitation plan without IBC, triggering, if there is a failure of rehabilitation plan, can somebody go and file a liquidation application to, liquidate the corporate debtor under IBC? So this pertains to that. So basically, the appeal has been filed under Section 61, challenging order of NCLT, dismissing application under Section 33. So somebody filed a liquidation application under Section 33 of IBC, and that was dismissed. The brief facts are like this. JK Synthetics is the company in question. It was declared as a SIC industrial unit by BFR 1998. Then they entered into an MOU with Arfat Petrochemicals Limited, which is the respondent here, on the basis of which appellate authority for your financial reconstruction, they approved and sanctioned the scheme, rehabilitation scheme. The appellant herein, he claims to represent the workforce and work union and of JK Synthetics. He filed an application under Section 33, read with Section 34 of IBC. So basically a liquidation application alleging that rehabilitation scheme has been breached and the corporate debtor should be liquidated. So the company is in continuous breach of sanctioned rehabilitation scheme and is unable to meet out its responsibility and liability towards creditors, etc. The appellant in the application relies on notification of central government dated 24th May 2017. So much of the judgment will be talking about the notification only, and couple of case laws which have referred to the notification. The notification considered that rehabilitation scheme sanctioned under implementation is a resolution plan within the meaning of IBC. In the application, the applicant claimed that an order of liquidation be passed in terms of Section 33. So the application was heard by NCLT, and in order dated 2021, NCLT framed two questions: whether sanction scheme of rehabilitation is a resolution plan within meaning of IBC in view of May 2017 notification, and they found out that no, it's not a resolution plan under IBC. Second, whether it can be held that respondent has committed the breach, respondent company has committed the breach of sanction plan, and is it liable for liquidation under IBC? Again, NCLT said no. So basically, after hearing the parties, NCLT in its order rejected the application filed by the appellant, which was the union, workforce union, and they rejected the application under Section 63. They came to the conclusion that sanction scheme of rehabilitation dated 2005 cannot be termed as a resolution plan under the code. It was further held that the rehabilitation scheme, not being a resolution plan, there is no question of respondent company committing breach implementation of plan. Hence, an application under Section 33 is not maintainable. So basically, even when you have a resolution plan under IBC and there's a breach of terms of that plan, then also it triggers a ground for liquidation application. Basically, here they say when it's not itself a resolution plan, so the breach of that scheme cannot be called a violation of resolution plan, and again you can't have a ground for triggering liquidation under Section 33 of the code. Agreed by this order of NCLT, the appeal was preferred by the appellant. So the learned counsel appearing for the appellant, challenging the NCLT order, he submits that there was a removal of difficulties order dated 2016, and they say that it could not have been set aside by NCLT, nor actually it has been set aside by NCLAT. So basically, they say this notification is still there, it's valid, and there might have been some remarks about the notification, but it has not been set aside. So they refer to a case, Smartech Ceramics India Limited. This is an important case which has been referred again and again. This was decided by Honorable Supreme Court as well. So the observation by this tribunal, they say that the observation by NCLT in the Spartak case was that the notification dated May 2017 is in conflict with maximum period granted under Section 61(2). That's on the limitation. Hence, the NCLAT could not have entered in the appeal it cannot be read to mean that the notification has been set aside. So they basically say that NCLAT, while deciding on the notification, said that there is an issue of limitation, but they did not set aside or call the notification as illegal. It is further submitted that the NCLT in its judgment refrained from giving any specific declaration with regard to notification. Hence, the notification survives. So they again are pressing on the point that the notification survives, it is still valid. They further submit that the judgment of Honorable Supreme Court in the Spartak case, while dealing with the notification, had only made observation which was being an obiter, that means an oral observation, and cannot be held to be a declaration of law. So they say again, Supreme Court has not gone into legality of the notification, so they have not set aside the notification. The Honorable Supreme Court in Spartak judgment has only upheld the judgment of Honorable NCLAT, by which sanctity and authenticity of the notification is not affected. It is further submitted that the NCLT, while its judgment and order dated 2021 in matter of, so there was a similar matter in the Arafat Petrochemicals case. So they say the NCLT by such an order has given liberty to operational creditor to file an application under section 33 subject to compliance of relevant provision of law while refusing to entertain application under section 9. So they say the NCLT has given liberty to trigger section 33 while not entertaining section 9. So they say when application under section 9 has been refused to be entertained with the liberty like to file section 33, that NCLT could not have rejected the application under 33. So basically what they say is they draw in a similar precedent, their own case. They say section 9 was rejected, but I was having the liberty to file section 33 there, right? And when such section 9 is refused and such liberty has been given, then the NCLT should not have rejected the section 33, which I filed for breach of rehabilitation scheme. The learned counsel for the respondent, refuting the submissions, submit that the approved rehabilitation scheme, this is the counter now. They say that the approved scheme is not a resolution plan within the code. The notification dated 2017 has been held to be in excess of jurisdiction of central government and cannot be relied by the appellant for filing application under section 33 and 34. This appellate tribunal has held that the notification travels beyond the scope for removal of difficulties provisions. So this notification was under that removal of difficulties order. So they say they contend that the NCLAT itself has held that this notification travels beyond the scope of that removal of difficulty provision, which finding has been approved by the Honorable Supreme Court as well in an October 2018 judgment. Hence, the reliance on the said notification for holding approved scheme as a resolution plan is wholly erroneous, and no application on the basis of approved scheme can be filed under 33 or 34 under the code. And NCLT, they say NCLT has considered all these aspects, and has rightly rejected the application filed by the appellant. The learned counsel for the respondent further submits that this Honorable NCLAT in his judgment dated January 2019 in a separate case, Gale India versus Nacer Limited, has already taken a view, relying on the judgment of Honorable Supreme Court in Spartak Ceramics India Limited, that notification dated May 17 is illegal and travels beyond the scope. It is further submitted that the rehabilitation scheme has been fully implemented, and for implementation of scheme, Rajasthan High Court, there is a justice appointed by Honorable Rajasthan High Court as well to oversee that implementation of scheme. And they have submitted an inspection report observing that all dues have been disbursed. It is further submitted that the payment of dues under the scheme to the respondent has already been crystallized and were offered, which were around 1 lakh rupees. The settled amount is not being received by the respondent to drag the company into liquidation. He's saying the respondent is deliberately dragging the company into liquidation. Already we have disbursed the amount, but he's refusing to encash the check. So he's saying initiation of the proceedings under section 63, it itself is fraudulent with a malicious intent. Then in class says we have considered the submission. They frame the question as this now. Whether application filed by appellant under sections 33 read with section 34 of IBC was maintainable. So they say the basis of application was approved rehabilitation scheme dated 2005, alleging contravention of which the application was filed before Honorable NCLT. The primary question is whether the approved rehabilitation scheme is a resolution plan within the meaning of code. The appellant in his support has relied on certain orders. He has given removal of difficulty order, and this removal of difficulty order they have reproduced area. They say so basically section 242 of the code provided a 5-year window which said that if there is any problem in implementing IBC, any provisions of IBC, the government can bring in certain provisions. So basically that reads as this: in excess of power conferred under. So this is the removal of difficulty order. which came down in 2017. So now, therefore, in exercise of powers conferred by section 242, the government hereby makes the following order to remove the above said difficulties. So this is order 2017. They say that, provided that any scheme sanctioned under subsection 4 or any scheme under implementation, so any sanction scheme or any scheme under implementation under the Sikh Industrial Companies Act shall be deemed to be an approved resolution plan under section 31 of the code, and the same shall be dealt with in accordance with provisions of the code. So based on this, basically, people said that if rehabilitation scheme is a resolution plan, a violation of that resolution plan should allow for section 33 application. But this order itself has been called to be illegal and, traveling beyond the scope of what legislature, gave it the power to travel. So this was observed by NCLAT, then affirmed by Honorable Supreme Court as well.
Badri, can I interrupt
Yes, sir.
with a question?
Yes, sir.
See, originally that means whatever was decided in a BIFR, that scheme which is approved was to be treated as a resolution plan.
Yes.
But later Supreme Court struck it down. Is it like that?
Yes. In the Spartak case, first NCLAT struck it down, saying that this particular notification, it travels beyond the scope, because here we are not removing difficulty in relation to IBC. We are dealing with Sikh Industrial Act, not IBC. So they basically said the notification travels beyond the scope of section 242.
Okay.
Yeah. So this was held by Apex Court in Spartak Industries case itself, that, NCLAT has said it rightly, and under section 242 of IBC, you cannot have such a notification.
Right.
Then,
okay, thank you,
sir. So then section 242 has been reproduced as well to say what the section says is basically, if any difficulty arises in giving effect to the provisions of the code, the central government may make such provision not inconsistent with the provision of code as may be necessary, right? And no such provisions can be made after 5 years from enactment of code. So basically, when we read down the judgment, it basically says that to remove difficulties with IBC, you can make provision. But in the notification dated in May 2017, there was nothing to do with IBC. It was dealing with Sikh Industrial Act. So that's why it traveled beyond the scope. The notification dated in May 17 came for, again, now they are explaining the history of how they've decided against the notification. So the notification came for consideration before this Honorable Tribunal in Spartak Ceramics India Limited. The order dated May 2017, the removal of difficulty order, was extracted by NCLAT in the above judgment in para 17. The appellate tribunal noticed section 242 of the code, and following was laid down in paragraph. So they're laying down the order again, which they have given in an earlier case. So they basically say the notification aforesaid mentions the following difficulties. So again, they have reiterated the same section. Then they say, from plain reading of the ground as shown in the imputed notification dated May 17, we find that the notification has been issued in view of difficulties arising to give effect to review or monitoring of the schemes under SICA Act. It does not relate to removing any difficulty arises in giving effect to provisions of INB code, which is the only ground for which central government can exercise power conferred under section 242. In absence of any ground shown for removing difficulty in giving effect to provisions of IBC, and as the central government cannot exercise power conferred under 242 of the IB code for removing difficulty arising under the SICA Repeal Act or Companies Act, this Honorable Tribunal cannot act pursuant to notification dated May 2017. This was the order in Spartak case, which was then confirmed by Honorable Supreme Court. They said it was held that the order dated May 17 does not relate to removal of difficulties in IBC. Again, some observation was made by NCLAT to maintain judicial decorum. Though we have noticed the conflict in the order passed by some conflicting order were given at that point of time by Honorable Delhi High Court, we refrain from giving any specific declaration. In spite of observation, the next question requires consideration is of otherwise appeals maintainable, the impugned scheme is legal or not. So basically, they decided on section 242 on the notification in a previous case. So they say the order passed by NCLAT was challenged before Honorable Supreme Court in a civil appeal. The appeals were disposed of by an order dated October 2018. Then they say it is useful to extract and reiterate the order of Honorable Supreme Court. They say basically Apex Court held that NCLAT, we are of the view that the judgment of NCLAT holding that the appeal filed by central government in that case is not maintainable, and it travels beyond the scope, the notification travels beyond the scope of the removal of difficulty provision is correct. So they say NCLAT decision is correct. We are of the view that having held that appeal is not maintainable, NCLAT should not have adjudicated upon either limitation aspect or the merits. So they basically say when appeal itself was not maintainable, NCLAT need not have gone further into it. Therefore, while upholding the judgment passed by NCLAT on the ground that appeal is not maintainable, we set aside the judgment insofar as it purpose to deal with limitation aspects. So basically say we agree with the law point of NCLAT saying that the notification travels beyond the scope, and we set aside the order because it's not required to be decided. Then they basically say that, some writ petitions are pending before Honorable High Court, and they say that now the writ petitions may be revived, and Honorable High Court was requested to, consider these writ petitions at the earliest. So that was the Honorable Apex Court judgment. Now, the submission of the appellant in respect of the above judgment is that Apex Court judgment, the appellant says the Apex Court judgment is only an arbiter, and it does not become a law. And then Honorable NCLAT says that it is they basically say that the Honorable Supreme Court in Para 2 clearly noticed the view of NCLAT that notification travels beyond the scope of difficulties provision, which observation was approved. The judgment of NCLAT has been upheld. Thus, the judgment of Honorable Apex Court clearly lays down that the notification travels beyond the scope. It has also noticed the orders of Delhi High Court, where a High Court has ordered the parties to avail alternative remedies. After upholding the judgment of NCLAT, the Honorable Supreme Court has revived 2 writ petitions filed before Delhi High Court, which makes it clear that notification was treated as notification not to be given effect to. So basically, NCLAT says you can't call this an obiter. It's a very clear affirmation by the Apex Court of the Honorable NCLAT order to say that the notification traveled beyond its scope. So they say we are not in agreement with the Learned Counsel of Appellant, and that the Apex Court judgment should be treated as obiter. The Apex Court has clearly approved the view of NCLAT, and now it's a law declared by Honorable Supreme Court under Article 141 of the Constitution. The judgment of NCLT impugned in the present appeal follows the judgment of Honorable Apex Court in Spartex Ceramics. When the notification is not a valid notification, there is no occasion to accept the submission that approved rehabilitation scheme, which is the foundation of the application filed under section 33 or 34, can be treated as a resolution plan. The very foundation of the application having been knocked out, the application was rightly rejected by adjudicating authority. The Learned Counsel for the respondent, they again take up some more cases which have been referred by the respondent, and they say basically that these cases are not in sync with the facts and circumstances of the current cases. The Learned Counsel of the appellant has laid great emphasis on NCLT order in one Surendra Singh case. So the NCLAT says that the said observations were made by NCLT in section 9 with liberty to operational creditor to file an application subject to compliance of relevant provisions of law. The above order does not notice the judgment of Honorable Apex Court in Spartex Ceramics. Hence, the order of NCLT cannot be held to be any binding precedent to be followed. Then appellant has also relied on some more judgment of Delhi High Court. The Delhi High Court in the above judgments has also considered notification. The above judgment had no occasion to notice the judgment of Honorable Supreme Court because this has been disregarded by Honorable Supreme Court. So they basically say whatever precedents you have provided before me, they either don't take note of the Honorable Apex Court judgment, or it was in the point prior to the Honorable Apex Court judgment. So it's not considered in the current circumstances of the case. The Learned Counsel for the appellant placed reliance on certain judgments of NCLT Bombay, Chennai, Delhi bench as well. And judgment of NCLT Ahmedabad in Surendra Singh Hada case, they already wrote about it above. And they say the judgment of NCLT Bombay bench, in which the judgment NCLT had no occasion to notice the judgment of Apex Court, hence cannot be treated as binding precedent. So everywhere they say other cases referred cannot be treated as a binding precedent. We are of the view that the judgment of Honorable Apex Court in Spartex Ceramics is a law declared by Honorable Supreme Court. Honorable Supreme Court has specifically approved the view of this appellate tribunal. Notification May 2017 travels beyond the scope of difficulties provisions. We have already, they say that we have already extracted the relevant provisions. The power under section 242 is thus confined to powers of central government in removing difficulties arising in giving effect to provisions of IBC. So nothing apart from IBC. The powers cannot be exercised by government to remove any difficulty regarding review, monitoring of scheme under SICA, Repeal Act or other act. And they say that which is the specific reason mentioned in notification May 17, noticing the difficulties which has arisen for which order has been issued. It is useful to know the following part of the notification which these difficulties has been arisen. So basically again they reiterated the notification part. We thus are of the view that no error has been committed by NCLT in rejecting application filed by appellant under 3334. There is no merit. So basically, what this is, resolution plan, rehabilitation plan under a SICA repeal act is not a resolution plan. When it's not a resolution plan, a violation of such plan cannot be a trigger for section 3334 under IBC. So they have clearly laid down the view again, which already was there from Honorable Apex Court, saying that the May 2017 notification travels beyond the scope, and we will not consider that, and using that we will not allow any rehabilitation scheme to be considered as a resolution plan. So that's the thick and thin of it. Any questions on this case, or we will take up the next case?
Yeah, you can take up the next case. You have explained it clearly. It's very clear.
Thank you. Anybody else? Any questions? Everybody shy. The next case is a bit big, a bit confusing as well, but I'll give the crux of it first. Again, NCLAT judgment, 2022 only, 5th August 2022. So this is Vikas Daya, ex-director of Golden Tobacco Limited versus Arrow Engineering and Golden Tobacco. So basically, this judgment is on the doctrine of res judicata. So to put it in a very short form, basically, CRP was initiated in a company. The shareholder and the suspended management were not happy with it. So they filed an appeal. It was affirmed by Honorable NCLAT also. And then, in Supreme Court also it was decided. And then the again matter came to NCLT. In NCLT, again, when an application was filed for the CRP, again, these people, the director and the shareholder, they raised new grounds, similar grounds, but from a new angle, to say that, Honorable NCLT cannot pass an CRP order without considering our pleadings. So basically, that NCLT ordered the CRP and RP got appointed. Then these people filed appeal in Honorable NCLAT against that new application for CRP, and Honorable NCLAT said the doctrine of res judicata applies. The case was affirmed by NCLT, and then Honorable Supreme Court. Then again, it went back to NCLT just for a direction. Now you cannot come and raise the same questions which have already been heard and decided. So it's a very detailed judgment given on the doctrine of res judicata. So with that in the background, now if we read, we'll get more clarity. So these two appeals, so there are two appeals, so that's why a common order has been passed. These two appeals are filed against common order passed in NCLT Ahmedabad 2021 case, and order date was 7 June 2022. As both these appeals are filed challenging a common order, raising common grounds, it is expedient to decide both these appeals by a common judgment. So Honorable NCLAT has given a single judgment. So they say the appellant in company appeal 699, though there are two appeals, 699 and 812. The appellant in company appeal 699 is ex-director of Golden Tobacco, whereas the appellant in the other appeal is claiming to be a shareholder of Oval Investment Private Limited. To avoid confusion, parties arrayed in the appeal are called as appellants and respondents. Appellant in appeal 699 was the respondent in appeal number. So there is a lot of appeals and applications. So we'll try to cut down all that to maintain some clarity. So the appellant was there. So corporate are Arrow Engineering Limited. So Arrow Engineering Limited is the financial creditor who filed an application against before the NCLT Ahmedabad to institute CRP process under Section 7 of the code. So Golden Tobacco is your corporate data, and here the appellant, one appellant is a shareholder, one appellant is the suspended management, right? So, and Arrow Engineering is the financial creditor. So Arrow Engineering filed a Section 7 petition against the company. The said application was dismissed by NCLT on various grounds. So Section 7 filed, got dismissed. Aggrieved by the NCLT order, the applicant, Arrow Engineering, the financial creditor, he preferred an appeal before Honorable NCLAT. The Honorable NCLAT, after hearing the counsel on record, passed a detailed order, formulated certain points regarding limitation, relationship between financial creditor, corporate creditor, acknowledgement of debt, everything, and some were reiterated. They framed two questions in that appeal: whether the company owed a financial debt to Arrow Engineering, whether the balance sheet contained acknowledgement of debt for purpose of Limitation Act. and whether the application filed under section 7 was barred by time and rightly rejected by NCLT. So these were the questions framed by Honorable Enclave at that point of time. All these three questions were answered against the appellants herein and in favor of the respondent Aero Engineering. So, unfavorable order was given for financial creditor, admitting several provisions of IBC, more particularly section 3 subsection 11 and section 5 subsection 8 on financial debt and other provisions of Limitation Act, decided all the points against appellant ex-director. So all the points were decided against the ex-director and in favor of financial creditor. This tribunal, that means the NCLAT, finally concluded that NCLT committed a grave error in dismissing the application filed by financial creditor under section 7, set aside the order while allowing the appeal, and issued the direction to NCLT to pass consequential order, including order of moratorium from the date of receipt of order copy. So aggrieved by this NCLAT order, so section 7 dismissed, financial creditor went to NCLAT, NCLAT set aside the NCLT dismissal, ordered NCLT to revise and issue a consequential order. When this NCLAT order came, the appellants got aggrieved. They filed before Honorable Apex Court. The Honorable Apex Court then was pleased to dismiss the appeal by an order dated May 22, confirm the order passed by Honorable NCLAT in the appeal. So basically, it should have gone back to NCLT. After confirmation of order passed by this appellate tribunal by the Apex Court, the NCLT passed the impugn order as directed by this tribunal. So as the NCLAT had told NCLT to revise the order, and when the NCLAT order was confirmed by Honorable Supreme Court, NCLT passed a consequential order. Aero Engineering, a financial creditor, filed an IA claiming the following reliefs: allow the present application, commence the CRP, pass further direction as required. The application filed by financial creditor was allowed with the following order. So basically, NCLT gave these following directions. That the application is admitted, right? As seen from the above operative portion of the order passed by NCLT, it is evident that the CARP is commenced by NCLT, appointed one IRP to complete the CARP process. Aggrieved by the aforesaid order, aggrieved by the aforesaid NCLT order, Mr. Vikas Daya, ex-director of Golden Tobacco, corporate debtor and Oval Investment, claiming to be a shareholder, filed these appeals in NCLAT now. The appellants in both the appeals contend that the order of NCLT, which flows because of the Supreme Court judgment confirming the NCLAT judgment, the order of adjudicating authority is silent as to the pleas raised by these appellants regarding relationship of financial creditor and corporate debtor, limitation, acknowledgement of any debt, etc. So basically, they say now when it has come back to NCLT and NCLT has now passed an order, this order does not consider all the questions we raised. In absence of any specific findings on the issues raised by appellant, the order passed by NCLT is ex facie erroneous. It is also further contended that the civil appeal, they say the civil appeal which was preferred before the Supreme Court was only challenging the order of remand. So from NCLAT to NCLT when it went back. So they say the civil appeal was limited only to the challenging the order of remand and not against the finding recorded by the tribunal in the company appeal. So they basically say when we moved the first company appeal, when the first company appeal was there, that did not have anything on the findings. And when the appeal was made before Honorable Supreme Court, it was challenging the order of remand from NCLAT to NCLT, not on the findings affirmed by NCLAT. So they are basically saying NCLT should have again decided all the issues or heard all the pleadings before allowing the CRP. Specific contention of the appellants in both the appeals are there was no operational or financial debt, and the claim of financial creditor does not attract either section 5 or 5.7 or 5.8 of IBC, and has drawn attention of the court to judgment. There is a judgment which they refer to contend that to maintain an application, there must be a financial debt, and also relied on another judgment in Mukesh Desai versus Piyush Patel. The appellants also contended that there was no acknowledgement of debt, statement of account, particularly balance sheet of the company, mentioning debt of financial creditor. So they say there is no acknowledgement, there is no statement of account, but these aspects were not considered in detail by NCLT, and they simply passed an order under section 7, admitting CRP and appointing an IRP. Therefore, the admission of application and the IA of financial creditor is illegal and requested to set aside. During the hearing, the learned counsel for the appellant contended that in absence of any finding recorded by NCLT as to the subsisting legally enforceable financial debt and acknowledgement, the order is illegal. NCLT did not consider the question of limitation. The order of NCLT is ex facie erroneous and requested to set aside the common order. The appellant Oval Investment, the other appellant, they contend that we are a shareholder of the company, and merely because there is no appeal against the finding of appellate tribunal, the appellant is not debarred from challenging legality of the order, as it would seriously affect the right of shareholder. So they say, although there is no appeal against the finding of appellate tribunal, NCLAT had a very detailed order which then requested NCLT to pass the CRP order, right? So they say there is no appeal against the appellate finding. That doesn't debar me from questioning the process. As the appellant was not a party to the earlier proceedings and before apex court, the appellant is entitled to assail the findings recorded. So a new guy has come who was not a party to the previous appeals, and he's saying now I'm entitled because I'm prejudiced. I'm going to appeal this NCLT order, new order admitting CRP in Honorable NCLAT. The appellant is entitled to assail the findings recorded by NCLT by filing an appeal under Section 61 of IBC. The judgment in application for initiation of CRP is a judgment in rem, and third party whose interest is affected may file an appeal at any time. So he says it's a judgment in rem. Rem means it's against the world. And when a CRP starts, the CRP starts, everybody is involved, and all the stakeholders is involved. Then even if you do a Section 12A withdrawal, it's there are judgments which say that once CRP is initiated, you have to consult all the stakeholders. Even a Section 12A cannot be only for recovery of a certain financial creditor. During the hearing, learned channel for the appellant contended that the appellant is a shareholder. He was not a party to earlier proceedings, and the application is now acting adverse to his interest. He placed reliance on certain apex court judgment as well. Now, the learned counsel for financial creditor contended that when the appellate tribunal NCLAT recorded its findings, considering all contentions raised in the appeal, all the questions were answered, and the order attained finality in view of judgment of apex court as well. Therefore, the appellants are debarred from raising similar contention which attained finality in support of his contentions. Then he placed reliance on certain judgment to say, the doctrine of res judicata, basically to say that already decided questions of law cannot be again entertained. During the hearing, the tribunal also raised a query as to the maintainability of the appeal on the same grounds which were raised in earlier round of litigation, and which were decided in favor of respondent and affirmed by Honorable Apex Court. Then the learned counsel for appellant contended that the shareholder, the other appellant, he says that since I was not a party, I am entitled to file an appeal challenging the findings. The learned counsel, in both they filed their written submissions, etc. All the pleadings were done. The appellants and respondents reiterated their contentions during the arguments, referred to certain judgments. Considering the rival contentions, perusing the materials available, the points that need to be answered by the NCLAT are as follows. So these are the questions framed by Honorable NCLAT. Whether the appellant in both the appeals are competent to challenge the order passed by NCLT, and when the findings recorded by this NCLAT attain finally in view of, so they say, can these appellants challenge the NCLT order when the findings of NCLAT was affirmed by Honorable Supreme Court? Second question is whether the order passed by NCLT suffers from any illegality or irregularity warranting interference of this NCLAT while exercising power under Section 61. So is there a need to set aside the NCLT judgment or not? As both the points are interconnected, they say we will have a common discussion. It is an undisputed fact that the financial creditor Aero Engineering filed an application which was dismissed by Honorable NCLT. Aggrieved by the order, the financial creditor preferred an appeal, which was allowed by NCLAT by judgment dated December 2021. At this stage, it is relevant to advert to certain findings recorded in that order. So basically, they go on to all the consultations which happened during the first appeal. The basis for the contention is that the MOU was signed by cooperator and first respondent, which clearly states there was an arrangement between the cooperator and first respondent to carry on joint venture and development, while the cooperator agreed to provide land, who was to provide financial assistance for development of project. There was no relationship between the cooperator and financial creditor. In the absence of proof, the debt due was financial debt as defined. The application is not maintainable. So all these contentions which were raised at that point of time were discussed. Then they say the order of this Honorable NCLAT, and there's one line which says that the same was assailed in company appeal, where this tribunal reversed the order passed by NCLT and allowed the appeal while directing NCLT to initiate CRP, appoint IRP, and impose moratorium. The order of this tribunal attained finality in view of the apex court judgment. This tribunal framed 3 points which we referred in earlier paragraph for consideration, and this tribunal adverted to the contentions. This appellate tribunal records its finding as to the acknowledgement. So basically, they refer to their earlier judgment to say that, see, these points were already decided by us in the earlier judgment on the limitation aspect, on whether there's a financial debt or not. These findings were, and they say these findings were affirmed by Honorable Apex Court as well. The appellants during the hearing contended that though the findings recorded by appellate tribunal attained finality, as the appellants only questioned the remand order. So the appellant is saying, I'm only questioning the remand order from NCLAT to NCLT, right? So they say that if the appellants say like that, as the appellants only question the remand order passed by tribunal in the first round, therefore the principle of res judicata has no application to present case. So the appellants are saying the res judicata doctrine doesn't apply here because there I only challenge the remand order. Now I am going to question the legality of the order. Undoubtedly, the principle of res judicata is a principle enunciated under Section 11 of Civil Procedure Code. Therefore, the rules of CPC has no application to this tribunal. So the tribunal says, of course, CPC rules does not apply here in view of Section 238 of IBC, but still the appellants are not entitled to raise such pleas which were already decided by this tribunal, as it amounts to abuse of process of law. So this is the important finding which has been given in this judgment, saying that you have to apply the doctrine of res judicata, and you cannot raise similar grounds and challenge similar grounds and result in abuse of process of law. Then they refer to Honorable Apex Court judgment, which says that doctrine of res judicata is not a technical doctrine, not only applicable to records. It's a fundamental doctrine of all courts that there must be an end of litigation. Halsbury laws, they also add that the doctrine applies equally in all courts, and it is immaterial in what court the former proceeding was taken, provided only that it was a court of competent jurisdiction, or what form of proceeding took, provided it was really for the same cause. So the cause should be same and the court should be of competent jurisdiction. Res judicata, it is observed in as corpus juris, is a rule of universal law pervading every well-regulated system of jurisprudence, and is put upon two grounds embodied in various maxims. One is public policy, other is necessity. So basically say, see, if on the same grounds, same issues, people keep on litigating, there is no stop to it, plus the courts will be burdened. Then they also explain on the rule of estoppel that once you have admitted to something, you have lost a case in Honorable Apex Court, it becomes a law of land. You are not allowed to, irritate that fact again. So after advertising the laid down decisions in various decisions of Apex Court, concluded that the erroneous judgment will not operate as res judicata. The judgment of this tribunal cannot be held as erroneous, as the judgment was confirmed by Apex Court. So basically, the NCLAT says, if my judgment was erroneous, then doctrine of res judicata would not have applied. But my judgment was confirmed by the Apex Court. If for any reason the judgment is held to be erroneous, it would be amounting to review not only of the judgment of this tribunal, but also Apex Court. So if you are questioning the validity of my judgment, you're also questioning the Apex Court. This tribunal is incompetent to exercise a jurisdiction to review its own judgment or judgment of Apex Court. Hence, we are unable to accede to the request of the council. Then they again refer to one more Apex Court judgment, which again lays down on the doctrine of res judicata. Res judicata is thus a doctrine of fundamental importance, though it is stated to belong to the realm of procedural law being embodied in Section 11 of CPC. However, it is not a technical doctrine, but it is fundamental in our legal system that there has to be end to all litigation, this being the public policy of Indian law. The adverse side of this doctrine is that when applicable, if it is not given full effect, an abuse of process of court takes place. However, there are certain notable exceptions as well. One well-known exception is that the doctrine cannot impart finality to an erroneous decision of jurisdiction of a court. Likewise, an erroneous judgment on a question of law which sanctions something that is illegal cannot be allowed to operate as res judicata. Then again, they quoted the famous IBC judgment as well, saying that doctrine of res judicata is applicable to proceeding of IBC as well. So although the tribunal says CPC provisions might not apply to me, but res judicata is a doctrine which applies to all court because of the Apex Court judgments. In view of the principle laid down in the above judgment, doctrine of res judicata is applicable even to proceedings under IBC, and challenge to the findings, incidental or collateral proceedings, amounts to an abuse of process of court. In any view of the matter, when the appellant raised a specific ground before the NCLT and before this NCLAT in the first round of litigation against the order passed by NCLT, and when it's affirmed by Honorable Apex Court, again raising such grounds in second round of litigation in incidental proceedings is nothing but an abuse of process of court. Though the learned counsel contended that the appellant only challenged the order of remand to NCLT, the findings with regard to remand attain finality in civil appeal. So they say the findings of NCLAT was affirmed by Honorable Apex Court, and not the remand was based on those findings as well. Assuming for a moment that civil appeal was preferred challenging the finding of this tribunal with regard to remand of the matter, still the findings recorded by this tribunal on various other contentions raised by appellant became final. In fact, the appellants did not place on record the grounds of appeal, which was decided, and in absence of the appeal grounds, this tribunal has no other alternative except to reject the contention. The appellant only challenged the remand order. So when they made the appeal, they have not put the grounds of appeal of Honorable Apex Court. So the NCLAT says, if you say you only challenge the remand order, you don't put any other grounds as well. So we can't entertain this, right? And anyways, other contentions have been affirmed by Honorable Apex Court. The appellants are precluded from raising the same contention in the present appeal. Then the counsel for the shareholder appellant, they say it was not a party, so it's entitled to assail the findings again, and they relied on certain judgment. So here NCLAT says the Honorable Supreme Court, while deciding arbitrarity of dispute, distinguished the right in rem and right in personam. So some discussion on right in rem and personam went on. Since the adjudication by this tribunal is in effect a right in rem, the appellant being shareholder filed the appeal. The law declared by Apex Court is not in dispute, but the appellant herein is claiming interest through the corporate debtor. When the corporate debtor challenged the same, applying doctrine of res judicata in view of law laid down by Apex Court in Apex case, and the judgment has attained finality, the appellant, the shareholder appellant, who is claiming interest through corporate debtor, is debarred from restating the same things by the doctrine of res judicata. So basically, it says that although this person might not have been appellant in original round of litigation, but since the facts have been affirmed, the law has been affirmed, is debarred from raising the same issues again. And because it relates, the same issue relates to the same corporate debtor. Say the counsel contended that the appeal was allowed, still the appellant, who was not a party, he can challenge the same, and he referred to some Supreme Court judgment. Shareholder claiming right through corporate debtor, judgment against the corporate debtor is binding on its shareholders. As law laid down by Apex Court is not in quarrel, the facts of this case are distinguishable from the facts of the judgment referred by the counsel. In the instance case, the judgment of the tribunal is merged with the order of NCLT and through the civil appeal, through the Apex Court decision. There's a finding recorded by this tribunal has attained finality. So they say our finding has attained finality already. Those findings cannot be challenged in incidental or collateral proceedings. The claim of appellant is hit by doctrine of res judicata and abuse of process of law. At this tribunal, exercising powers under section 61, while deciding the earlier company appeal, adverted to all contention of both the parties and recorded specific findings. So there was all the questions were answered in the first round of litigation, and then Apex Court confirmed it. Even assuming for a moment that those findings were not challenged by the appellants, still the judgment became final. Therefore, the appellants either in 699 or 812, these are the two appeals here which we are discussing. The appellants in either appeals are disentitled to re-agitate the findings recorded by this tribunal and affirmed by Apex Court in the incidental proceeding. This tribunal cannot sit in appeal over its own order and cannot review its own order. So again, the respondent also gave one case law saying that, they should not be entertained. In addition to the above judgment of Apex Court, there is one more judgment which held that the judgment attained finality, it cannot be reinstated in any collateral or incidental proceedings. In Union of India versus Major S.P. Sharma, the Apex Court held a decision rendered by a competent court cannot be challenged in a collateral proceeding for the reason that it is not permissible to do so as and when chooses, and the finality of the proceeding would cease to have any meaning. So once some issue has reached finality, you cannot disturb that. Applying the principle laid above in the above judgment to the present facts to give quietus, to silence the issue, to give quietus to the dispute and to avoid abuse of process of court to challenge the judgment which attained finality, the appellants must be non-suited. In view of the principle laid down above, the principle of res judicata, though a part of civil procedure code, it would be applicable to proceedings of this tribunal and IBC, only to prevent the abuse of process of law and give a finality to any proceedings or orders and avoid an endless litigation to frustrate the very object of enacting IBC. The claim of appellants is liable to be rejected. Indeed, A judgment obtained by playing fraud on the tribunal or a judgment or order passed without inherent jurisdiction is known as in the eye of law, and the same can be challenged in a collateral incidental proceeding. Like we read, if it's an erroneous judgment, then the doctrine of res judicata would not have applied. But it was not the case in these appeals. Hence, in any collateral or incidental proceeding, the judgment cannot be agitated, which attain finality. If such course is permitted, it would amount to exercise of power of review of its own judgment or sitting over the judgment in appeal against its own order, which is impossible under law. Learned counsel for the appellant contended that the respondent is entitled to raise objections. Such contention is liable to be rejected. It lacks no merit in view of principles laid down by Honorable Apex Court. So they say the contentions of counsel are rejected while holding that the appellants are disentitled to reinstate the findings recorded by this tribunal, both on facts and in law, which have attained finality in view of the Apex Court judgment. In view of the discussion, we find no illegality in the order passed by NCLT dated June 2022, since NCLT complied with the direction of this NCLAT, passed consequentially to the Apex Court confirmation. We accordingly find no merit in the contention of appellants. We find no grounds to warrant interference by this tribunal. Accordingly, the points are held in favor of the respondents, respondent financial secretary, aero engineering, and against the appellants in both the appeals. In view of these findings, we find the appeals of the award of merits deserve to be dismissed, and hence these are dismissed. So basically, they say you cannot just create new parties and on the same collateral or incidental issues, you cannot keep on coming to the forum and disturbing the finality. So once the issue has been decided in final, any collateral or incidental questions cannot be raised just to disturb the proceedings. And I think for the first time, Honorable NCLAT has went down this detail to explain the doctrine of res judicata and how it's going to apply in IBC cases. I think this is the first case where it's very clearly laid down that the doctrine will be applicable for IBC proceedings as well, and not only just CPC proceedings. So these are the three cases which we were supposed to discuss. Any questions on this case? If you're shy to talk, you can put it on the chat box. Yes, sir.
Badri, I have only one doubt here. See, then some place they said NCLAT cannot review its own judgment.
Yes.
It is not impermissible. It's not permissible under law. It's saying.
Yes.
Judicial review is not permissible in law under IBC.
Sir, we have seen, see, this is something new for me also, because in NCLT, there have been some instances where NCLT does review the orders. I think the tribunal can, make its own rules and regulations. They have the liberty to do that.
Or maybe here, because Supreme Court has decided, it
maybe
cannot
that's
review
why, sir.
now.
Maybe that's why, because in NCLT, there is a revision or review provision, which is there in the NCLT rules, and they can very well draft their own rules. Since CPC doesn't apply, they can also.
As you rightly said, because it has reached a finality based on Supreme Court's judgment.
That's why.
Now they cannot review it. It's almost like reviewing Supreme Court's judgment.
That's why very clearly they have said, if you're questioning the legality of my order, it's like you're questioning the Supreme Court order also, which is law under Article 141 of the Constitution now. So they don't want to step into that zone and offend the order.
That's true. Okay.
Any other questions, anyone? I'm not sure if this has been taken up by any faculty or not, but there is also a new case law, Honorable NCLAT only, which says that the Provident Fund dues claimed by PF department has to be paid in full by a resolution applicant under resolution plan. This is an NCLAT case, which refers to a NCLAT judgment in Jet Airways case. That's also very peculiar, that we always know PF dues, everything is operational creditors, get paid as, a haircut. But now it says entire PF dues has to be paid.
Okay, is there any questions you may ask?
No, sufficiently answered. I don't think I have any questions.
Okay, I think there are no questions. So thank you so much, Mr. S. Badri Narayanan, for the session. It was very detailed and informative. And thank you for taking the session.
Thank you so much for calling. Thank you.
So now the next session will be taken by Mr. Ashok Juneja. He will be taking following 3 NCLAT cases. One is Mr. Somesh Chaudhary versus Knight Riders Sports Private Limited and another's company appeal insolvency number 501 of 2021. Second is Sri Alok Kaushik RP of Kima Spintex Limited versus Kima Spintex Limited and others. And the third one is White Stock Limited versus Prajay Holdings Private Limited. So let me briefly provide you the introduction of Mr. Ashok Juneja. Mr. Ashok Juneja is an advocate, insolvency professional and valuer. He is also director of Mantra Insolvency Professionals Private Limited, registered with IBC as IPE. Mr. Juneja has also handling more than 60 assignments along with the other directors of the IPE as IRP, RP, AR, liquidator, voluntary liquidator. Mr. Ashok Juneja has also handled numerous cases of IBC as an advocate and is also legal consultant to many IRPs, RPs, liquidators. Mr. Juneja is a law graduate, company secretary, cost accountant, MCOP, and has an overall combined experience of more than 45 years in corporate laws, including appearances in Supreme Courts, High Courts, National Company Law Tribunal, National Company Law Appellate Tribunal, DRT, etc. Sir, you may now start the session.
और unmute हो गया.
Good evening to everybody. Today we are taking up three cases which are delivered by the Honorable Appellate Authority, that is NCLAT. So first case relates to Santosh Chaudhary versus Knight Riders Sports Private Limited.
यहाँ ये जो दिख रहा है ना, इसको इससे नीचे कर लेना.
So should we start?
Yes, sir.
Okay, if anybody has any questions between, he is most welcome to ask in between also. Otherwise, at the end of each case also, I will be asking everyone whomsoever has any questions, he may ask at that time also. So first, I am grateful to the institute for giving me this opportunity to share some of my views with you. So first case is Santosh Chaudhary versus Knight Riders Sports Private Limited. You know, this is a case which is under section 9 of the IBC. This was regarding operational character. Here the main question was that whether the appeal was made by one of the shareholder. You know, the corporate debtor itself cannot make the appeal because the corporate debtor is in charge of the charge of the RP. Therefore, normally whenever there is an appeal, any promoter director does the appeal, and the IRP is also made one of the respondents since he is in charge of the company or the CD. So here the first question was, so let's go start reading just a moment. So there was an order of the National Company Law Tribunal, New Delhi, bench number 4. There are 6 benches in the court. There are on the bench number 4. So the order was delivered impugned order was delivered on 5th July 2021. And the one of the shareholders and suspended director of the board of the corporate debtor preferred this appeal under section 61. The main issue of this appeal was that whether there was an agreement wherein the minimum guarantee or license guarantee was to be provided by the corporate debtor to the operational creditor, and plus a variable guarantee amount was also to be given by them. There was a license agreement between both the parties, and under this agreement, the corporate debtor was liable to pay an amount of rupees 80 lakhs, around 80 lakhs. Out of that, the disputed amount remained 40 lakhs something, wherein it was there that the 40 lakhs minimum guarantee was to be paid, royalty was to be paid by the corporate debtor to the operational creditors. Now, when they started this agreement, at the time of dispute, the out of the 80 lakhs something, around 40 lakhs and 60,000, 40 lakhs and 60,000 remained unpaid as the minimum guarantee royalty payable, and out of which also a payment of rupees 17 lakhs 69,835 has been made up to 15 June 2015. Since thereafter, quite a many invoices were raised by the operational creditor upon the corporate debtor, but none of the payment was made by the corporate debtor to the operational creditor. In fact, in between, one of the check for rupees 5 lakhs was issued by the company, wherein this corporate debtor was the appellant was one of the director over there, but that check was not accepted by the operational creditor because they said there is no preview of contract between that company and this company. So they wanted a check from this company only. After many times, the corporate debtor ultimately refused to pay anything, and then hence there was an appeal. There was along with the NCLT section 9, under section 9, the operational creditor filed a application with them. While deciding the application, the Honorable Tribunal NCLT came to the conclusion that yes, the debt was due and the operational debt was due, and they were payable. It was payable to the operational creditor. Therefore, they admitted the application. Against that, the suspended director and shareholder of the corporate debtor went to the appeal. In the appeal, the basic issue involved was whether this minimum license fee is a goods or services or not, and number two, whether the minimum guarantee was amount which was as a debt or not. Some subsidiary questions was also there, like whether there was a pre-existing dispute or not, and whether the demand notice under section 8 was properly delivered or not. These were the main issues. And the fact of the case is that there was an agreement in 2014, which was entered between the corporate debtor and the first responder, that means the operational creditors, and operational creditors were the owner of a trademark like Kolkata Night Riders, KKR to be in short. In terms of this agreement, the operational creditor has granted to the corporate debtor exclusive right and license to use the trademark KKR and with logo, and also to promote its KKR. And against that, the consideration was to be paid quarterly, each quarter, and a minimum guarantee amount was also to be paid by them. But what happened? They stopped giving any payment to the operational creditor, and therefore operational creditor, as per clause 4.1 of the agreement, payment of royalty to the respondent one by the corporate debtor So they went to the, and as per clause 4.2 of the agreement, provided for a guaranteed minimum royalties. So they went to the Honorable NCLT that this debt is due, and since they are not paying, therefore an application should be admitted under section 9 of the IBC. And interest was also to be paid in case of default or delayed at the rate of 1.5% per annum per month, that means 18% per annum, or the maximum rate permitted by the law, whichever is low, whichever is less, and along with any cost, attorney fee, etc. Then the operational creditor raised several invoices upon the corporate debtor. However, the corporate debtor deliberately or intentionally did not make any payment of the total amount due and payable to respondent number 1. And then the OC also sent many reminders in this record, but the CD did not respond. Then there was an email from the corporate debtor of 11th June 2015, 29th November 2015, and also the reminder email dated 21st November 2015, 10 December 2015, and 21st December 2015, sent by the OC to the corporate debtor, seeking for payment of the amounts. Then, while so on 11 June 2015, the CD gave a post-dated check for a sum of ₹8 lakhs issued by the Extreme Perfumes and Personal Care Private Limited. That means a third party, though in which the CD director was also a director therein. But the OC returned that check with the same saying that there is no preview of contract with the Extreme Perfumes, therefore he cannot accept the payment from Extreme Perfumes. Then there was an email dated 13th June 2015 by the corporate debtor, wherein the corporate debtor stated that the delay in payment is on account of pending commitments and that ₹5 lakhs was being transferred by RTGS and the balance amount would also be paid in the month. Therefore, 2 checks of rupees for an amount of 10 lakhs each were handed over by the corporate debtor to the OC, but subsequently these were dishonored and on the ground that the payment was stopped. That means the corporate debtor stopped the payment of this check after issuing these checks. Since by this mail of 30th June 2015, the corporate debtor has agreed to pay the royalty and moreover has also transferred an amount of ₹5 lakhs to RTGS and also 2 checks of 10 lakhs. So there was no dispute as far as the payment was concerned. So a demand notice on 28th March 2018 with a complete annexes were served upon the corporate debtor under section 8 of the code. Now the payment was also, the notice was sent to the corporate debtor email ID registered in the company's master data. That is on the MCA record, whatever the ID registered ID was there of the corporate debtor, to that the notice number 8, the demand notice under section 8 was sent. The adjudicating authority also observed that there was no pre-existing dispute between the parties and allowed the section 890 application. Now assessment. The brief point which arose in this appeal is whether the amounts claimed by the first respondent falls within the definition of operational debt as defined under section 5 subsection 21 of the code. Now section 5 subsection 21 of the code says that operational debt means a claim in respect of the provision of goods or services, including employment or debt or the service of the payment of dues arising any law for the time being in force and payable to the central government, any state government, any local government. That means the operational creditors who are traders or service provider, workers or employees or state governments are comes under the preview of operational creditors. Now, the main case is that the minimum guarantee royalty under the agreement, he said, does not arise because the goods or services are not covered under the ambit of operational debt as defined under section 521 of the code. So now we have to see that what section 2 subsection of the sale of goods. Now the basic questions was whether this minimum guarantee royalties falls under goods or service or not. So the first of this was that they said that this is not defined under section 5, subsection 21 of the IBC. So then in that case, appellate authority, honorable appellate authority, went to the various other definitions as section 2, subsection 7 of the Sale of Goods Act 1930, which states that goods means every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, gross and things attached to a and forming part of the land, which are agreed to be sold before the sale or under the contract of sales. Then section 3, subsection 27 of the code says that property includes any money, goods, actionable claims, land, and every disposal property situated in India or outside India, and also discussion of interest, including present or future, or vested or contingent interest arising out of or incidental to the property. Now, again, section 2, subsection JB of the Recovery of Debts and Bankruptcy Act, DRT, it says that property to include intangible assets like trademarks also. Therefore, the Council for the Operational Creditors submitted that the Honorable High Court in Madras in Duroflex Private Limited versus Duroflex Setting System also outlined this, examined the issue of jurisdiction of the court in case of infringement of trademarks, and observed that the right and investment interest in a trademark is a movable property. So the trademark is a movable property. This was established. Now the Honorable Madras High Court also considered in this judgment Shabir Medical Hall, that as well as in Ramu Hosries, that, and came to the conclusion that trademark is a movable property. So this was this conclusion made it very clear that trademark is a movable property. Now, whether this trademark is actionable under IBC or not, for this, the Apex Court, Supreme Court case in Vikas Sales Corporation versus Commission of Sale Tax examined the definition of goods and observed that even incorporeal rights like trademarks, copyrights are movable property and are included in the ambit of definition of goods under the provisions of Sale of Goods Act. That means trademarks, copyrights, etc. are defined as are covered under the definition of goods. So it was understand the meaning of guaranteed minimum royalty. What is a guaranteed minimum royalty? That a minimum annual royalty or guaranteed minimum royalty is a payment made periodically by a licensed to a licensor pursuant to a license, regardless of sales success for a licensed product over that rule. Unlike a royalty, which is usually calculated as a percentage of net sales revenue. A minimum royalty is generally an agreed amount, lump sum payment of the reasonable expected revenue from the sale of a licensed product over the agreed time period. A larger bench of the tribunal in Jaipur Trades Export Center Private Limited versus Metrojet Airways Training Private Limited in Company Appeal 80-423 observed that if an expression is not defined in the statute, then the meaning of the expression in general parlance has to be considered for finding out the meaning and purpose of expression. Section 7, scope of the supply, read with entry 5 of Schedule 2 of the Central Goods and Services Tax Act 2017 permits the use or enjoyment of an intellectual property right as a supply of services. The Honorable High Court also, in the case of AGS Entertainment Private Limited versus Union of India, examined that the issue whether the temporary transfer permission to use the copyright in a cinematograph film granted by its owner to another person amounts to the provision of services. The Honorable High Court held that the same constituted provision of services by the owner of the copyright or the other persons. In this case, the corporate director was permitted to use the trademark of KKR in relation to his licensed product, and hence the appellate tribunal noted that this was there was temporary transfer permission to use constituting provision of services rendered by the first respondent, and that means OC, and this falls within the power definition of service and amounts to a due and payable. Rising of such services is a operational debt. Therefore, it was decided by the appellant, first issue, it was decided by the appellant authority that it is a operational debt. And further, the OC also said that they had paid service tax to the government authorities on the invoices raised against the corporate debtor. As the invoice itself contemplated payment of GST for the use of services rendered by the OC on which GST is payable, the definition of service under the Central Goods and Services is applicable to the facts of this case. So said, since the service tax has been also be paid by the OC, and therefore the definition of service under the Central Goods and Service is applicable to the facts of this case. That means minimum royalty, whatever the invoices were issued, they have paid the GST also. Now, the contention of the appellant was that the term service has not been defined expressly under the code, and therefore the definition cannot be lifted from the statute, and that this issue is clearly covered by the judgment of this tribunal in M. Ravinath Reddy. They said that the appellant's counsel argument was that this is unsustainable, keeping with the judgment of a 5 members larger bench in the tribunal in Jaipur Trade and Vessel this, where it was observed that para 39 of that observed that in any case this is a definition of service is under the Consumer Service Act 2007 are not covered by the section 3317 of the Code. Ultimately, they held that this tribunal did not dwell upon the correct meaning of the expression services used in the section 5, subsection 20 of the code, and therefore this 5 bench, larger bench, held that the such services are to be included as services and are admissible under section 5, subsection 21. So hence the licensee was licensed for a particular kind of service for use for the licensing for running a business of education institutions. Hence, in the present case, debt pertaining to unpaid license fee was fully covered within the meaning of operational debt under section 5, section 21, and the adjudicating authority committed error in holding that the debt claimed by the operational creditor is not an operational debt. The judgment of this tribunal in the Pramila Taneja's case reiterated the law as laid down in M. Ravinath Reddy case. We, having held that judgment, case does not lay down the correct law. Therefore, this 5-member bench of NCLAT ruled over the this M. Ravinath Reddy case or Pramila Taneja case. So, in view of this foregoing discussion, the 2 questions larger bench in the following manners. Number 1, judgment of the tribunal in M. Ravinath Reddy as well as judgment in Pramila Taneja case does not lay down the correct law. Dusra, the claim of the license. Second, the claim of the licensor for payment of license fee for use of demised premises for using purposes and operational debt within the meaning of section 5, subsection 21 of the code. Keeping in view these judgments, it was held, keeping in view the ratio, this aforesaid Jaipur Trade Export Center Private Limited Supra, it is clear that the claim of the licensor for the payment of license does fall within the definition of the operational debt, within the meaning of section 5, section 21 of the code. So the appellant authority observed that the judgment relied upon the learned counsel for the appellant, namely Ravindranath Reddy and Pramila Taneja, were held to be bad in law. So therefore, they said, since that is overruled already by this 5-member bench in Jaipur Trade Export, therefore that was held by the appellant authority to be the authority for this purpose. So in the instant case, the OC has permitted number A to use manufacturers sell, distribute, and advise the licensed products, and also to use the intellectual property rights, trademarks, KKR, brand logo, and other trademarks, which is as the first respondent may designate in its sale and absolute discretion or in association with the licensed products in India, as well as on packaging, promotional and advertising material associated therein. So we are on the considered view that the claim of the respondent in respect to the provisions of the goods and services for which the corporate debtor is contractually obliged to make the payment towards such claim. The clauses of the agreement provide for the royalties to be paid as a variable amount to the first respondent and the minimum guaranteed amount to be paid as fixed payment as stipulated under section clause 4.2 of the agreement. So it was after consider view, it was held by the appellate authority that the OC has established a right to payment in respect of the provision of goods and services. So, a granting of the exclusive right and license to the corporate debtor to use, manufacture, sell, distribute, and advise the licensed products to use the trademark in association with the licensed product as well as on packaging, promotional as a direct nexus with the business operations and sale, and also the actual products supplied by the corporate debtor. Hence, it was held by the appellate authority that the claim in respect of such provision of goods and services under the terms of the agreement fall within the ambit or definition of operational debt as defined under section 5, section 21 of the code. So, appellate authority first issue was decided in favor of the operational creditor that the provision of such supply of such services, including license as a minimum guarantee license, falls under the definition of operational debt under section 5, section 21 of the IBC. So now the second question was before the appellate authority whether there was any default in the payment or not. So the operational creditor, so the email dated 1/10/2015 together with the checks dated 15 September 2015 and 20th October 2015 issued for amount of rupees 10 lakhs each clearly construed the admission of the corporate debtor that the amount was indeed due and payable. So that also established that there was no dispute as regards to the payment. Therefore, they have issued post-dated checks also, and also 5 lakhs amount was through RTGs was paid. At this junction, we find it relevant to reproduce the email dated 1st October 2015, which reads as follows. This was the email sent by the corporate debtor to the operational creditor, wherein they said that as far as the royalty is concerned, really we have not earned anything for the last 9 months. Still, we will pay the royalty as per our commitments. Let's our account check what exactly the royalty amount will be after deducting TDS. But to keep this brand in continue, we will deposit 10 lakhs through RTGS by Tuesday next week positively. On clearance of 10 lakhs, we will discuss the matter once again with you to pay the balance and to discuss about how to go forward strategically with the brand. Remaining amount, once our account confirmed about the actual payment, we will pay maximum by the end of this month. But from next month onwards, after making all strategy, we will do the needful in time. So this was the mail sent by the corporate debtor to the operational creditor and to the corporate debtor to the operational creditor, which clearly stated that they are making the payment and there is no dispute, except that though they stated that for the nine months they have not earned anything, but that is not material because it was a minimum guaranteed amount. So therefore, the appellate authority, appellate tribunal held that if there is a clear admission on behalf of the corporate debtor that the amount are required to be paid and would be paid in time. The third was whether there is a pre-existing dispute or not between the parties, and that Section 8 notice was never served upon them with the complete set of annexures. Now they said that they found that on 25th April 2018, the email sent by the OC to the CD clearly states that the annexures have been appended. The contention of the counsel for the corporate debtor that in the very same email dated 24 October, it is stated that the record established that the corporate debtor had willfully and actually avoided the service of the notice, and therefore this statement proves that the notice was never received by them is untenable. So they said the demand notice was sent on the email ID of the corporate debtor, which was shown as under the MCA records. So it is a sufficient notice, and all the annexures were annexed thereto, and therefore both the things that there is no pre-existing dispute and that under Section 8, subsection 2, subsection A, clause A, read with Section 5, subsection 6 of the code, either with regard to the existence of the amount of debt or with regard to the quality of goods or service or regarding the breach of representation or warranty either directly or indirectly. So the submission of the CD, that the ratio of this tribunal in Jindal Steel Power Limited versus DCM International Limited is applicable to the fact of this case is untenable, as the issue in Jindal Steel was with regard to the default in non-refund of the security deposit amount given by the operational creditor, to the whereas it has no relevancy with the facts and circumstances of the attendant case in hand. So in all these for the aforesaid reasons, the appellate authority said that we do not find any illegality or infirmity in the well-reasoned impugned order of the London Educating Authority, and therefore this appeal fails and accordingly dismissed. No order as to cause. That means ultimately the appeal by the appellate authority was dismissed, and they held that the amount was due and payable, and therefore the admission order by the NCLT, by the executive authority, was perfectly valid and in order. So this was the judgment given by Justice Anand Vijay Singh, judicial, and MS Srisha Merala on 18th August 2022. So any doubt, any questions on this particular case? Or should we proceed to the next? Should we proceed to the next?
Yes, sir.
Okay. So now we proceed to the second case. Out of the third case, the three cases are total to be discussed. And this second case is regarding just a moment, please. The second case today, which we are going to discuss, is regarding Alok Kaushik, the just a moment, please, which is regarding IRPs. So very, very important case as far as we all IRPs and RP are concerned. This is a very, very interesting and very important case as far as we all IRPs and RPs are into the practice. This is relating to our IRP fees and expenses. So in this case, what has happened that there were certain expenses and IRP fee, which was not sanctioned by which was not approved by the NCLT, though it was approved by the COC. And then when the IRP approached his IRP, because he was not made, though he was made RP by the COC, the appellate authority also upheld the decision of the educating authority, and they also held that fee and expenses not payable. Now the fact of this case are that the IRP Mr. Low Kaushik, he was appointed as IRP of Chima Syntax Limited, CD. And the operational character, again, it's a Section 9 application. Operational character, Kotak Commodity Services Private Limited, has made an application against the corporate debtor, that means Chima Syntax Limited, and it was admitted, and Mr. Kaushik was appointed as the IRP in this case. Now, what happened, that the fact of the case is that since IRP was not granted its fee demanded by it and expenses, he appealed. You know that under Section 61, the appeal can be filed by the agreed party of the IBC with the Honorable Appellate Authority. So it has to be filed within 30 days with the grace period of 15 days, of course. And then on 30th, and it was filed by the IRP of the order dated 30th May 2022 by the Chandigarh bench. In the IA number 510/221 and CP number 352. So what happened in this Pune order, the executing authority dismissed the main petition, which was filed under Section 9, and released the corporate debtor from the rigors of the IBC, subject to the payment of 8,36,001, whereas the almost total fee was claimed by total fee and expenses was claimed of 25,77,000 by the IRP as a CRP cost, which included its expenses and as well as its fee. Against that, only 8,36,001 rupee was granted by the executing authority. So the appeal was then preferred by the IRP against this cost and expenses, And what happened, that the RP moved an application under Section 12A and Regulation 30A of the IBC. You all aware that 12A is a section which allows the case to be withdrawn if the 90% of the COC agrees for that. And if it is before the COC is formed, then under Regulation 30A, 31A of the regulations of IBBI, through the IRP, if the settlement is there by the applicant who has initiated the CIRP and between the corporate debtor, then it can be withdrawn. It may be withdrawn by the executive authority on filing the application by the IRP. And IRP is duty bound once the agreement comes to it to file the application within 3 days of the agreement of the agreement of settlement and the Form FA received by it. So what happened, that there was an agreement between the there was a settlement agreement between the corporate debtor and the operational creditor and the ex management of the corporate debtor. They also filed an application on 22nd October 2001 seeking the withdrawal of CRP, and the IRP also made an application under Regulation 30A clause A for withdrawal of the application on 18th October 2021. That is almost after 12 days of admitting the application by the Honorable NCLT. That means, though no constitution of the COC was formed, because it was to be formed within 30 days, and he filed the application within 12 days after it was admitted by the Honorable NCLT. But what happened in the meantime, the ex-promoter of the corporate debtor also filed an application after 4 days, that means on 22nd October, for withdrawal of the CRP process. But in the so the IRP submitted that application with the adjudicating authority. Just a moment, please. Just a moment, please. There is some technical problem. Sorry, there is some technical problem is coming up. So the fact of this case is that under section 9 of the IBC, an application was filed before the adjudicating authority by this Kotak Commodity Service Private Limited operational caterers for initiating the corporate insolvency resolution process. The CRP is initiated under section 5, subsection 11 when the application is filed, and when it is admitted, the commencement starts from under section 5, section 12, the CRP commencement starts. So it was filed by that, and against that application, the application was admitted, and this commencement of the CRP was commenced. Then as I stated earlier, that since there was a settlement agreement between the corporate debtor and therefore an application, and the corporate debtor and the operational creditor, an application was made of the settlement agreement was made on 12th October 21, and the IRP through IRP and the IRP with form FA as prescribed under regulation 30A submitted the application for withdrawal of the CRP. On 18/10/2021, that means after 12 days of admission. Then the ex-management of the corporate debtor, CD, also filed an application on 21st October 21 seeking withdrawal of the CRP. Then they also, in addition to the IRP, they also filed an application seeking stay on the CRP proceedings of the corporate debtor. Then the IRP, what happened in the main case? In the main case, because there was 3 financial creditors also involved therein, including Punjab National Bank. So there was no stay on by the NCLT, Honorable NCLT, on the operations of the CIRP, neither on the operations of the CRP nor any embargo on the constitution of COC. The IRP, in addition to filing the application, also went ahead with the CRP procedure with the contention that if it does not follow it, unless the CRP is withdrawn by the Honorable NCLT, there may be repercussion on him for not following it, the CRP properly. Therefore, he constituted the COC also with the financial creditors, and the COC also, the meeting was also held COC because there was no embargo or restriction or stay on holding of COC or on CRP proceedings. So since in the meantime, there was various hearings were held, and on 26 October 21, then 18th November 21, then 4th January 2022, then 17th February 2022, then 22nd March 2022, then 30th March 2022, and also on 5th April 2022, where in all the times the IRP was present over there. So, and ultimately, the financial creditor in the meantime, that is Punjab National Bank, also filed an application under Section 7 of the IBC. But the Honorable Tribunal directed them to file the claim with the IRP and not to file an additional application under Section 7 to avoid the multiplicity of litigation. So as per IBC, they said you file your claim with IRP and let him handle that claim, and you cannot file an additional application under Section 7, since under Section 9, one application has already been admitted. But since at the same time, so they filed the claim with the IRP, and with all the three financial creditors, he made the IRP with all the three other the IRP made the COC as per the provisions of IBC. And then there was COC was held, and in the first meeting he was appointed as RP also, and his expenses and RP fees and others also was also approved by the COC. And similarly in the second meeting and third meeting also, he went ahead with the CRP procedures, since no final withdrawal of the application was admitted by the NCLT. One another point is to be noted that the section says it may be withdrawn. It does not say that the Honorable NCLT shall withdraw. That means the option is with the NCLT, seeing the circumstances, whether to permit withdrawal or not. Therefore, the IRP or the RP is under an obligation to carry on with the CRP proceedings till the case is withdrawn, finally withdrawn by the Honorable NCLT or any other appellate authority. But then he also faced was non-cooperation from the ex-management of the corporate debtor, since they did not provide custody records of the assets. He also filed an application IRP under Section 19, subsection 2, seeking directions for cooperation from the ex-management of the corporate debtor. That and also that with the view that under Section 20, he has to run as the company as the CD as a going concern. The IRP also incurred expenses which had been placed before the COC and duly ratified by the COC. It was also claimed that the IRP, besides this, as a CRP exercise, he held 6 COC meetings and also submitted 10 progress reports filed with the COC, including the steps undertaking for valuation of the assets of the corporate debtor. But it has been claimed that the authority on 30th March 2022, while considering the stay application, you see he applied in October 21. Then the final applications were heard by the adjudicating on 30th March 2022. That means almost a 1.5 year, while almost after 6 months, while considering the stay application of the corporate debtor, and also directed the applicant to file the details of the fee charged for conducting the business of the corporate debtor. Now, while furnishing his expenses, though those are not given in this appeal, but it was placed before the NCLT the details of the expenses. So there were almost 17 items upon which the IRP or the RP has filed its expenses details. These are amounting to 25,77,643. And these mainly related to the e-voting agencies, advocates, publishing house, security services, advocate, then transaction auditors of the CRP, registered valuers, IRP fees, then advocates for PUFE application. So in total, 17 items were there, which aggregating to rupees 25,77,000. So the plea of the IRP, the appellant in this case, was that he has done he has taken all the steps which are required to be taken under the IBC provisions, regulations, and rules. But when he submitted these details to the educating authority, which were expenses which were duly ratified by the COC also. But the educating authority said that no, the applications was filed for withdrawal before the constitution of COC. Therefore, no requirement of section 12A, that means of passing the 90% voting power by the COC was required. This was number one. Second, they said that since this applications filed before that, the IRP should have been reasonable in expending it, making expenses and its fee. He should have pursued the educating authority to take final call, not waiting for 6 months. Whereas the IRP has attended every meeting, whatever held during this time. And in the court, sometimes the IRP has to go with the directions of the court. My personal opinion is that since he has gone there 6 times and the application was being heard every time, the undue delay in disposing of the case itself cost CRP cost. But anyhow, the learned educating authority said that no, they only passed expenditure up to 8,36,001 rupee only, and they did not pass out 20,89,000 expense. They said they categorized the expenses in 2 parts: essential expenses and non-essential expenses. They said that the IRP has incurred some non-essential expenses, therefore is not authorized to claim those expenses. So the IRP was aggrieved by this decision, and therefore he approached this appellate authority. And whereas he said that the essential and non-essential expenses is a differentiation, is a artificial creation, which is not in the terms of IBC. Nowhere IBC provides that this will be the essential and this will be the non-essentials. It only says reasonable, but essential and non-essential category is not there. And moreover, the IRP also claimed that the IRP appeared regularly before the educating authority on each assigned date, which testifies that he has been diligent in pursuing the CRP withdrawal application filed by him. Hence, despite the best possible efforts put in by the IRP, the educating authority has been wrong in not appreciating the conduct of the CRP and made reverse remarks without cogent reasons, which should therefore be expunged. So there were 2 things: not only that the educating authority approved only 8,36,000 expenses against total expenses of 25.77 lakhs expenses. He also made some undesirable comments about the IRP, about its conduct and about his intentions. So he said that this should be expunged, and also he should be allowed to have full expenditure on that. In para 15, the IRP, where he said that IRP has himself, where they said that it is noted. Now the appellate authority, while deciding the case, said that in para 15 of the educating authority decision, it is mentioned that it is to be noted that the IRP has himself filed IA this number only after 12 days of commencement of CRP, but has chosen to continue with normal functions under CRP without pursuing the IA this and this with the educating authority. Even if it may be technically correct, but it does not synchronize with the spirit of the code. It also noticed that the directors have not handed over the records and assets to the IRP subsequent to their settlement with the operational creditor. This bench therefore proceeded to categorize the activities for which expenses have been claimed as mentioned in para 14 into 2 different categories: essential and non-essential. So the appellant said that appellate authority also that we are of the view that the activities mentioned in serial number 1 to 7 of the aforesaid mentioned table in para 14, 1 to 7, the expenses comes to rupees 4,87,674, and in para 14, costing of expenses on account of e-voting, security services, publishing houses, payment to advocates, and transaction auditors as essential, and allow the expenses incurred on those activities, which comes to, I told you, 127, 4,87,675. Again, besides that, the expenses relating to the valuation are disallowed because the directors have admittedly not handed over the records and assets. Similarly, the payment to advocates for PUFE transactions, PUFE means under section 43, 45, 15, and 66, transactions are applicable under preparation is disallowed because in the absence of the records, it is difficult to justify any payment for the preparation of such an application. While therefore the adjudicating authority said that while we allow the expenses of IRP amounting to rupees 1,48,237 and the payment towards his fees is restricted to rupees 2 lakhs, and we strongly disapprove his conduct in not pursuing the present application filed by him himself only and necessary, adding to the cost by the carrying out non-essential activities. In the result, the CRP cost are allowed to the extent of rupees 8,36,000 rupee, 1 rupee only, and the same is to be reimbursed by the corporate debtor, that is Messrs. Chima Spintex Limited. You know, the impression of the adjudicating authority was that the IRP to make his own fee and expenses was lingering on with the CRP process, whereas as per the IRP, he was not lingering on, but he was trying to justify his actions as otherwise the IBB as a regulator, otherwise the ICAC, NCLT as the adjudicating authority may cause assumption on him if this application is not withdrawn. In that case, by the adjudicating authority, in that case, he would have been in deep trouble for not taking out the necessary activities which are he was duty bound to take under CRP. So that was his contention, IRP contention, but adjudicating authority has a different view, and therefore IRP filed this appeal against that. Now the appellate authority, after say that there we have considered detailed arguments and also the record carefully. Now there are 3 issues before the now appellate authority to consider. Number 1, whether in light of the admitted fact that the IRP himself filed the CRP withdrawal application on 18th October 2021, which was just 12 days after the commencement of the CRP, whether it was justified on the part of the IRP to still continue with the CRP proceedings. This was the first issue before appellate authority now. The second issue was whether the adjudicating authority had in disallowing the certain CRP expenses claimed by the appellant IRP by treating them as non-essential. Whether he was correct or not, this was the second issue in disallowing these expenses. And the third issue was whether the remarks disapproving the conduct of the IRP in the present matter by the adjudicating authority stands to reason, because IRP has also appealed against the remarks mentioned by the adjudicating authority. So he said whether those remarks are correct or not. So now he said the decision of the adjudicating authority was, number 1, he says that as a preference to our analysis, we have noted that the adjudicating authority has emphasized upon a few important timelines as abstract in a tabular form. He said that CRP commenced on 6th October 2021, 18th October 21, it was filed, that means after 12 days, it was filed by the IRP under section 12A and regulation 30A. And then on 22nd, one of the suspended director also filed an application for withdrawal. So both the application they said were before the constitution of the COC. And then on 6th November 2020, the first meeting of the COC took place. So before the COC meeting, both the applications were filed for withdrawal of the case. But then they said that coming to the factual metrics, the appellate authority is now giving its comments. It is an undisputed fact that the operational creditor, having entered into a settlement with the corporate debtor he had informed the IRP on 12/10/2021 that they are going into the settlement in the prescribed format, seeking withdrawal of the CRP. With 6 days, that means 14th October 2021, the IRP had also filed the CRP withdrawal application before the adjudicating authority. Just for information, the IRP is duty bound to file such application if it comes to him with the agreement and form FA, prescribed form FA, the IRP is duty bound to file the application within 3 days. But anyhow, it took almost 6 days, maybe some intervening holiday or whatever it may be. Filed the application on 22nd October, that means after 6 days. It is therefore amply clear that all the important stakeholders in the process were in unison in seeking closure of the CRP and awaiting final directions of the adjudicating authority. Where the appellate authority is saying, that means all the stakeholders wanted to withdraw the application, but whereas it is not true, because the one of the financial creditor itself filed an application under Section 7, and they held the meetings under constitution of the committee meeting. They were the part of all the 3 financial banks, financial creditors were part of the COC, and in that they ratified the expenses also, and it was almost went into the 3 COCs, and they never, under Section 12A, they never passed that resolution. But the appellate authority and the adjudicating authority stated that since the constitution, before the constitution, the withdrawal was made, withdrawal application was made, there was no need for the 90% voting power of the COC. So once it is withdrawn, once the application is there for withdrawal, the COC meeting does not have any consequences, or it is not material. It is observed that the IPRA had been present before the adjudication as and when the matter came up for the hearing the relative ICA, and that details of the expenses incurred on CRP was filed by the IRP pursuant to the order dated 30th March 2022 passed by the adjudicating authority. Yet another crucial point to be borne in mind is that while examining the expense details filed by the IRP, the adjudicating authority took cognizance of the fact that records and assets were not handed over to the IRP by the experiment of the corporate director consequent upon their settlement with the operational creditor, and therefore only the expenses found essential have been allowed, while the remaining disallowed and treated as non-essential. Now here the basic question comes that if the application is filed with the adjudicating authority, but it is not sanctioned or approved by the adjudicating authority for withdrawal, and there is no stay on the CRP proceedings or on the constitution of COC, whether the IRP should continue with the CRP proceedings or not. If tomorrow the application is not sanctioned or approved for withdrawal by the adjudicating authority, in that what will be the consequences or the fallback on the IRP for not carrying out the duties which are entrusted to him under the statute, that means under the IBC. So it's a gray area, because as per this appellate authority and the adjudicating authority, they said once the application has been filed, he should not have asked for the records and all those things, because he says that they did not file any, the corporate debtor did not give any records and to them, because there was then application of withdrawal has been filed. So this is a question for pondering and discussion in various forums, the implication of this judgment. And therefore only the expenses found essential have been allowed, while remaining disallowed and treated as non-essential. The adjudicator, after categorizing the cost as essential and non-essential, allowed the CRP cost to the extent of rupees 8,36,000 and 1 rupee, whereas the total expenses were 25,77,000 to be reimbursed by the corporate debtor. The adjudicating authority has also allowed certain amounts as the expenses of CRP, IRP, and payment towards his fees as mentioned in para 5 of the impugned order as in para 7 above. So the appellate authority said that given the material on record and the facts and circumstances in the present matter, the appellate authority said that they are inclined to agree with the finding of the adjudicating authority that since the Section 20A application was filed by the IRP before the adjudicating authority, well before the constitution of COC, the IRP's continuation with the CRP process without making any adequate efforts to seek pointed clarification of the adjudicating authority on whether to proceed with the CRP or not does not reflect well on his conduct. The IRP cannot afford to unmindful of the fact that he is driving force and nerve center in the resolution process and is expected to assist in the CRP process in a fair and objective manner in the best interest of all stakeholders. Simply by resisting presence on each date of hearing before the adjudicating authority without seeking clear guidelines on the CRP modalities cannot in itself become a sufficient ground for the IRP to proceed with the CRP with full throttle. As an officer of the court, it was incumbent upon the IRP to highlight before the adjudicating authority the special and peculiar circumstances that he was confronted with within the matter. Instead of pursuing the withdrawal application with greater vigor, he has rather chosen to mechanically proceed with the CRP by taking the plea of adherence to the CRP regulations. We therefore agree with the adjudicating authority that the conduct of the IRP through may be technically correct. The same cannot be countenanced given the attendant circumstances. So in other words, the appellate authority fully agreed with the adjudicating authority, and they said probably they also were of the opinion, are of the opinion that after the withdrawal application is made, the CRP proceeding should not be conducted in a full manner, and the IRP should take cognizance of that, and he should be very slow in pursuing the CRP process till the application is, though he has not mentioned it, but the language of their order judgment reflects in that manner. And then say that as regards the appellate authority further says that as per the CRP expenses claimed by the appellate and RP, we have observed that the adjudicating authority had directed the IRP to file the details of expenses, and the IRP accordingly submitted the expense details. The adjudicating authority in the impugned order has carefully examined the details of expenses and given cogent reasons for disallowing several items of the expenditure, treating them as non-essential. We find that the grounds cited in the ground for disallowing expenses, including the valuation expenses and payment to advocates, is justified. He says disallowing is justified, particularly because these tasks were contingent upon the records and assets being handed over the IRP by the ex-member of the corporator, which in fact had not happened. That the records and assets were not available with the IRP is substantiated by the facts that the appellant IRP on his own filed an application before the adjudicating authority for non-cooperation on the part of the former management of the corporator on 30th October 2021. They cancelled the contention of the learned counsel for the appellant, that means for the IRP, that creation of an artificial classification of the adjudicating authority of essential and non-essential during CRP is ultra-wise the provisions of IBC is not tenable argument, since the adjudicating has used these terms more as a easy reckoner to decide on whether to allow or disallow the item of expenditure and not acted in any manner contrary to the forms and despite of the IBC. So in nutshell, they said that we do not find any reason to differ with the evaluation exercise by the adjudicating authority. And again, they agreed, the appellate authority agreed with the adjudicating authority that they were right as far as the expenses were curtailed and their approval was only for 8 lakhs. So then they again, one thing they again said that in the spirit of section 2082A, which subjects to the insolvency reasonable to abide by the code of conduct, and also as per regulation 7 sub-regulation 2 clause H, which says clearly stipulates that the registration of the insolvency professional is subject to various conditions, and one of them being to abide by the code of conduct specified in the first schedule to these regulations. Now, Article 25 of the conduct they have mentioned, and which is regarding remuneration cost, and Article 25 of that schedule says that an insolvency professional must provide services for the remuneration, which is charged in a transparent manner, is a reasonable reflection of the work necessary and properly taken and not inconsistent with the applicable regulations. Now, as on today, the regulations of the regulator, that means IBC, by 30th September 2022, they have came up with the regulation that a minimum fee has been prescribed by the IBBA for the IRP and RP. Now, if that is minimum fee is charged by him, then it is inconsistent with the applicable regulation. That is one. Number two, if the fee is expenses and his fee is approved and ratified by the COC, again the COC is the authority which is reasonably commercially is authorized to accept the expenses or not. If the COC has ratified the expenses, the reasonableness of the expenses has to be seen by COC. But in this case, they held no, the expenses were not reasonable, even if the COC has approved and ratified, and they went against the IRP having those expenses and cost. So ultimately, they said that the expenses and the appellate authority upheld the decision of the adjudicating authority, and they said that the IRP seems to have taken advantage of the fluid situation and unnecessarily added to the cost by carrying out activities which could not have otherwise been put on hold, and find the conduct of the IRP depreciatory. That means, in other words, again they said even the remarks against the IRP mentioned by the adjudicating authority were right. So ultimately, under para 6, they said that we do not find any substance in the submission raised by the Learned Council for the IRP to warrant any interfere in the impugned order. The impugned order passed by the adjudicating not suffering from any infirmity is ever affirmed. The appeal being devoid of merit is dismissed, no order to the cause. And this judgment was given by Justice Ashok Juneja, who is the chairperson, who was earlier judge of the Supreme Court, and Barun Mitra, who has just retired, member technical, on 5th September 2022. Any question? Very important for IRPs. I think there must be some questions in your minds also. No question? Should we proceed to the third one? Third case? So any question from any participant?
No, sir.
Okay. So this judgment relates to the IRP cost, especially IRP fee and expenses. I was expecting that you must be having some questions on it. Anyhow, should we proceed to the third? Today's last case. Okay. The third case is White Stock Limited versus Prajay Holding Private Limited. This case is just a moment, please. Okay, now let's come to the third, that is White Stock Limited versus Rajay Holding Private Limited. So now, earlier two cases were under section 9. Now this case is under section 7. White Stock Limited, it's a Cyprus company. They are the financial creditors, and Rajay Holding Private Limited is the corporate debtor, and it's the Indian company having its registered office at Hyderabad. Therefore, against the judgment of Hyderabad bench, the financial creditor has gone to the appellate authority, and since it was in Hyderabad, the appellate authority has now let's so this was a judgment delivered by Justice M. Venugopal and Mr. Naresh Salecha. Right. So let's start with it. So there were two things. One was that the one in under 1 IA 10 days delay was prayed to be condoned. You know that under section 61, the timing are 30 days plus maximum 15 days condoned with reasonable reasons. So there was 10 days delay only, and they have allowed that. So this is not much relevant as on today. The point is that the company appeal was this 271. It was in Hyderabad. Therefore, it was decided by the Chennai bench. So this is that there was an order, impugned order of 13th May 2022 in CP number this and this. The main company petitioner referred for mediation to the what happened in this case, that the main petition which was filed under section 7 by the financial creditor, they referred it, the executive authority Hyderabad, they referred it to the for mediation to the International Arbitration and Mediation Center, Hyderabad. So in short, IAMCH, we say arbitration center. So to taken up what they said, that executing authority, that is, there is already a case going on between the companies, both the companies, under section 241 of the Companies Act. That means operation and mismanagement. Therefore, let it also be clubbed with that, and let it be with the ongoing mediation. This should also be clubbed over there. So, but the grievance of the financial creditor was that this is an application under section 7 of the code, and it cannot be clubbed under section with the arbitration, any arbitration under section 241, because this is a separate under IBC, and that is separate under 241 of the Companies Act. These both cannot be clubbed together. There is no nexus between these both the cases, and therefore it cannot be like that. But against this, but the appellate authority did not agree to their arguments, and they referred it to the mediation. So against this order, they came to the appeal before this tribunal. So the fact of the case are that the appellant, that means the financial creditor, is a Cyprus company, and they agreed, this White Block Limited agreed to operate it as a special purpose vehicle, SPV, Cyprus, and owned by a state general reserve fund. The respondent, that means Praja Holding Private Limited, they are engaged in the business of construction and real estate development activities, and they pursued their one of the promoters and ex-chairman and managing director, Mr. Vijay Sen Reddy Tantapalli, pursued the financial creditors to invest certain amount of money in their project that was named as Virgin Country. For the development of the project, they pursued them to have some investment. So the Virgin Country project related to the construction and development of an integrated township consists of luxury villas and group housing complexes, 4 to 4 apartments and 22 units to be constructed at the 85.9 acres site in Hyderabad. Now, there was an agreement on 3rd August 2011, and wherein there was a White Stock Investment Agreement, WIA. The financial creditor made the investment in the CD. The investment can be in the following. One was subscription to the CD, that means convertible debentures, not corporate debtor, convertible debentures issued by the corporate debtor of rupees 1.60 crores. These were fully and compulsory convertible debentures, in short CCD, with face value of rupees 1,000, carrying a coupon of 11%, rate of 11% per annum, to be issued to the financial creditor pursuant to WIA. The conversion date of these compulsory debentures to shares is the 8th anniversary from the date of the completion date, that is 10th August 2011. Also, a subscription to rupees 2,82,151 equity shares of INR 10 each at a premium of rupees 690 per shares. That means 10 each at a premium of 690, 700 rupees per shares, 2,82,151 shares, aggregating to Indian rupees 19.46 crores. They also entered into a sale and purchase agreement, so relating to the corporate debtor, and the total and also with purchase of 100 equity shares, the total investment was 197 crores was made by the financial creditor in the corporate debtor. And effectively, the financial creditor holds 22% equity shareholder of the corporate debtors. So as is normally done in case of such investment agreements, the article of association is amended to incorporate the commercial terms of WIA, that means investment scheme, and the corporate governance related issues. So there were issues as per Article 65F of the Article of Association of the carburetor. Any change in business plan was required to be made with the consent of the financial creditor. So these are normal business classes which are incorporated by the investor before investing in the Article of Association and in SHA also. And there were also financial creditor also nominated 2 directors. Now the project was to be completed within a period of 7 years from the start of construction, and that is by 19th February 2019. As per the WIA, that means that investment agreement, the financial creditor was entitled to receive coupon payments of 11% per annum commencing from 3rd November 2011 during the development period. Furthermore, at the expiry of the development period, all or any portion of the outstanding principal amount that were not repaid was to be converted into shares based on a conversion price. Now, in the original petition, the adjudicating authority, the financial creditor, brought out to the notice that the financial creditor had not received any return of investment in any form, and alleged that systematic, long-standing mismanagement and malice by the corporate debtor. And even they have around February 2015, the financial creditor came to know about adverse financial position of the corporate debtor. In the meantime, they also appointed PwC to conduct independent audit. The PwC gave a very bad report about this corporate debtor, and because according to which many irregularities were pointed out, including payment of rupees 6.8 crores, which remained unexplained and unauthorized. Use of funds for the meeting expenses not connected with the projects. The interest on debentures from November 2012 to 31st November 2017 amounted to rupees 59.24 crores has not been paid by the corporate debtor to the financial creditor and so on. The financial creditor also alleged issues relating the postage checks, fictitious board meeting. So many things were there which were against the corporate debtor. The corporate debtor has done not in accordance with the Companies Act or in the terms of the spirit or the terms of the agreement which was executed between both the companies. And so investors were very much aggrieved from the conduct of the corporate debtor. And therefore, they have filed this position. Earlier, the financial creditor had earlier filed a CP number 468 under section 241, 242 of the Companies Act. You know, 241, 241 is regarding operation and mismanagement of the Companies Act. So they have filed under that also. And against the corporate debtor, respondent is parent entity, subsidiaries, directors, promoters, and property additional directors before the executing authority. And the executive authority wide order there 24th December 21 in the company petition filed under section 241 in the CP number this and this by the financial creditor against the creditor referred the matter on mediation to this arbitration center. So that 241, 242 application filed by the financial creditor was referred under the Companies Act under operational mismanagement was referred by the executing authority to the arbitration center. Now the financial creditor also filed a petition 17 December under section 7 of the IBC. However, the executing authority, while its impugned order dated 30th May 2022, referred the section 7 application also for mediation to the arbitration center. Aggrieved by this reference for mediation, present appeal is filed before the applicant. So the financial creditor was aggrieved that why their application under section 7, which has no connection with the section 241, 242 of the Companies Act, has gone to the has been referred for mediation. So they appealed against the judgment, against the order of against the judgment of the executing authority, Hyderabad. So appellant's submissions were what the financial creditor said, that they gave a very chronological series of events, and that that they have subscribed to and purchased from around 2,80,000 equity shares, then compulsory convertible debentures, then they have not received anything from them, and they are almost and 20% of the equity share in their they are holding 22% equity shares in the respondent company. They also said that they have instituted a company petition under section 241 and 241 of the Companies Act and against the corporate debtor is parent entity, and which was referred by the executing authority to the mediation. Now the financial creditor grievance was that under section 241, the exclusion of the applicant from the governance of the independent company, non-service of notice of the brand shareholders, meeting of the parent and its nominee director, and shifting of the funds to the parent company of the corporate debtor. So they said that the amount are being siphoning off and the parent company by the corporate debtor. And they also said that they are defaulted interest of their 11% and at the renter to financial creditor to do to this. The financial creditor initiated under section 7 application and executing authority, and the amount at the state was 274.26 crores, almost 275 crores, which was principal along with unpaid accrued interest coupons with respect to CDS held by the financial creditor. So this was the amount which was due from the corporate debtors. Though the impugned order dated this and this, executing authority referred the proceeding under section 241. Now, the financial creditor argued that there are no connection, this application, with the earlier section 241 applications, petition section under section 241. Therefore, the mediation proceedings of the company affairs have no bearing on the insolvency petition. There is no provision in the IBC which states that it can be go for mediation. Then, being aggrieved, financial creditor also challenged the impugnment of 13th May 2022 in the present appeal. The London Council for the Financial Creditor alleged that the adjudicating has failed to appreciate the difference between the proceedings initiated by the financial creditor against the corporate debtor under section 241-242 of the Companies Act vis-a-vis under section 7 of the IB Code. Now, under the sale and purchase agreement, the investment agreement, the appellant was more as shareholder whose legal rights were being violated, and also alleged operational mismanagement by the corporate debtor under section 241-242 of the Companies Act. Whereas in section 7 of the application, the appellant was in his role as a financial creditor. So he said his role is different under section 241, and under section 7 of IBC, his role is different. Here his role is as a financial creditor. And that is the authority had not appreciated these two different roles of the appellant, and separate remedies available under separate section of the different act and code. The London Council further alleged that while the issues and reliefs sought by the financial creditor in section 2 petition under the with respect to return of funds siphoned out by the corporate debtor, financial participant in the corporate debtor is the brief sought in the innocent or with respect to the financial debt. So he said it's different. There we wanted to get our funds back, which has been siphoned out by the corporate debtor, and here we have actually have the debt for recovery of which for resolution which we are filing this application under section 70 under section 7 of the IB Code. And then the adjudicating authority, the financial creditor also submitted that as per the settled law, only options available to the adjudicating authority were two: either to admit the petition under section 5 or to reject the petition under section 5, section 7, subsection 5. So as per the financial creditor, they could not refer it to the mediation. Either they could have admitted it or they would have rejected it. But they cannot look like this, that they refer to third party for mediation. Because the financial creditor plea was that IBC code, being a complete code in itself, does not provide for an adjudicating authority to undertake any other course of action except the choices mentioned above. That means either to accept or to reject the application. And various decisions were quoted, like of the Supreme Court decision E.S. Krishnamurthy versus Bharat High Tech, or another Innovative Industry Limited versus ICICI Bank. The adjudicating authority under section that has occurred within 14 days, the same thing is saying under 14, either he should reject or reject the application, but he cannot refer it to the mediation. And this referring is an overreach on the part of the adjudicating authority. Does not, and IBC code also does not provide any such mediation. And he further said that there are catena of judgments of the Honorable Supreme Court of India, which says that the need for judicial intervention or innovation from the adjudicating authority should be bare minimum without disturbing the basic tenets of the INB code, IBC code. And also they referred on Krishnamurthy versus Bharat High Tech. Then again, the financial creditor relied upon the further judgments of Honorable Supreme Court in Pratap Technologies, in Arun Kumar, and in DRIP Capital Incorporated, and so on. So then they quoted the relevant para also, para 29, which states that the corporate debtor and the executing authority cannot move to the mediation for the judgment of under section 7. Then the so refer to the 7 proceedings for mediation under section 442 of the Companies Act was incorrect. Therefore, the mediation under section no such power to, and the executing authority has no such power to mediate, to send for mediation under section 442 of the Companies Act. And then again they said that section 238 of the IBC, which is a overriding, which gives the overriding effects, that if there is any inconsistency with the other law or something, that in that case the it will prevail. 238 section says that the provision of this code shall have effect notwithstanding anything inconsistent therewith contained in either law for the time being in force or any instrument being affected by virtue of any such law. So he says there is a overriding effect of section 238, and because of 238 also, the IBC cannot be equated with the Companies Act and mediation reference cannot be made. They also took the judgment of in CDOX India Services Limited versus Chemijol, and again then the London Council for the appellant, that means for the also voluntarily opposed the action of the executive authority for referring the petition for mediation. So various acts, various judgments, and various plea he gave, and and he said that the order of the appellate authority must, of the executive authority of 30th May 2022 must be important, must be set aside, and they should allow to have present appeal in the interest of justice. Now the operational corporate debtor have his own submissions, but they said it's a question, pure not question of law, but the NCLT being common for IBC and Company Act also, they are authorized to have such, to give such directions. And he further also, the counsel for the corporate debtor also said that recently Durba Industries Power Limited, the Supreme Court of India has held that the adjudicating authority, once it was found that debt existed and a corporate debtor was in default in payment of the debt, there would be no option to the adjudicating authority but to admit the petition under section 7 of the appellant had owned a company petition in this had referred the case to mediation center. So this also to be admittedly, the corporate debtor plea was that the NCLT authority has the authority to pass over to mediation for mediation, and since the admittedly with the consent of both the parties, and both the parties are consented for that. To this, the financial creditor disagreed, and they said that they have never consented for application under section 7 to be referred to the mediation. Okay, and so they also cited the case of Vijay, the corporate debtor also cited the case of Vijay Palgarg and others, and versus Pooja Berry, the liquidator in the matter of G Ispat Private Limited by its decision as per section 60 subsection 1 of the IBC code. The National Company Law Tribunal is an adjudicating authority possessing concurrent jurisdiction under the Companies Act and also under the IB code 2016. Now there is a concurrent authority, that is right, but then Companies Act is different and IBC is different. To the National Company Law Board, the IBC was also interested in when they in December. That is a different point. This honorable tribunal had held that as per section law and adjudicating authority possessing concurrent, they assailed the appeal and stated that the appellant failed to establish that it suffers from any legal grievances, and so the is not found. Now findings. The honorable appellate, their own finding are that they have pursued the submissions as well as their arguments. And the question is, number one, issue involved before them is whether there was a debt due to which default was committed by the corporate debtor, entitling the financial creditor to file an application under Section 7. Number 2, whether petition made under Section 241, 242 of the Companies Act can be equated with the application filed under Section 7. And the third, whether the Education Authority can refer application proceedings under Section 7 for mediation under Section 442 of the Companies Act. Now, these were the three issues. Against the one issue number 1, whether there was a debt due to which default was committed by the corporate debtor under Section 17, under Section 7 of the IBC code. Now, to understand whether it's a debt or not, the appellant gone over the various definitions. That means he went into the definition of first Section 3, subsection 7, which is the debt, which is under debt means a liability or obligation in respect of claim. Since the word claim is here, then they again went to the definition of claim under Section 3, subsection 6, which says claim means a right to payment, right to remedy for breach of contract. Then they went to the section of Section 5, Section 7 and Section 5, Section 8 of the IBC, which is 5, Section 7 says financial creditor, means any person to whom a financial debt is owed and include a person, such as refer to, and B, financial debt, means that along with interest and all the clauses they have referred therein. Thereafter, they also say up to HI classes they said. Now, similarly, they said default is also defined under Section 3, subsection 12, and they have also given the explanation of default means what? Default means non-payment of debt when whole or any part of the issue. So they said the financial creditor had subscribed to the purchase around these equity shares and compulsory converting, and they have the right to claim amount of rupees to 274 crores, and they are also holding 20% of the equity shareholders with 10% and 11% per annum on the CCDs. So therefore, they are the financial creditor under this. They are the financial creditors under under Section 7 of the Companies Act, under Section 7 of the IBC Act. So of the Companies Act. Then therefore, they said that after taking the definitions, all the definitions of debt, financial debt and default, the financial creditor claim that they are financial creditor is hold goods. So therefore, they said that they are the financial creditors ultimately. They said that the amount is a clear-cut debt, and therefore it is a debt, and therefore they are entitled for application under Section 7 of the IBC. So that regarding that, they were very clear, appellate authority, that is a debt under Section 770. And they also quoted the Bureau of Industry Power Limited versus Axis Bank, that what is an application under Section 7. So they put all the judicial judgments also to that, and several Supreme Court judgment also, including Krishnamurthy versus Bharat. And in 30 para, they quoted para 30, appellate authority of the Supreme Court judgment. Thereafter, so taking all this explanation, para and judgments of the Supreme Court, quoting Supreme Court, the appellate authority was of the considered view that it is a valid application under Section 7. Then this next was whether, second issue was whether petition made under Section 241 of the Companies Act can be equated with the application filed under Section 7 of the IBC code. So again, they went into the details, appellate authority, and they said that in Chapter 16 of the Prevention of Operations and Mismanagement, Section 241 describes application of tribunal for relief in case of operational acceptance, wherein Section 242 defines power of the tribunal with respect to Chapter 16 regarding prevention of operational mismanagement. So they said that this application is quite different, and there was an petition, earlier petition, CP 468, which was filed before the adjudicating under Section 241, is different, and it cannot be equated with the application under section 7(5). So the time is less, so I will conclude within 5 minutes. So the ultimate objective, the point put up by the appellate authority was that the section 241 and 241 cannot be equated with section 7 of the IBC. So therefore, this is a different point that they have been, the appellate authority, adjudicating authority has been delegated power to decide about the default or otherwise. Then the third issue was whether the adjudicating authority can refer application proceedings under section 7 for mediation under section 442 of the Companies Act 2013. Again, the adjudicating authority held that the appellate authority held that we have seen the power of the adjudicating authority under section 7, section 5 of the IB code, that while deciding an issue to retain the powers is limited to decide whether to within 40 days whether to accept, admit the application CRP or to reject it. So the Supreme Court judgment in Vidarbha Industry versus Accident did this. So the facts of the above case society is not Vidarbha Industry. Therefore, they said that we do not, we are not following the decision of the Supreme Court in Vidarbha Industries, because here the facts are different from that of the different, and therefore ultimately the conclusion or the operating part of the judgment was that I come to the operating part now. The operating part of the judgment is that since the adjudicator, they have referred the part in section 7 application IBC code this and this as a matter of this tribunal ordinary to the powers of the adjudicating authorities in 442, they are not under the IBC. They do not have any power to refer to the mediation. Therefore, it cannot be. They cannot refer. So result was, in view of the forced derivation reasons, the instant appeal is allowed. No cause. That means the appeal of the financial creditor was allowed, and it was referred again. The adjudicating authority is directed to pass suitable orders in respect of the application filed by the appellant under section 7. Or that means they referred back the application to the adjudicating authority to pass the judgment in terms of section 7 of the IBC. So the appeal was allowed, and the appeal was upheld, which was preferred by the financial creditors. So this was given by Justice M. Venugopal and Mr. Naresh, and it was Chennai Appellate Authority. So this covers all the three. Any questions? Any of the three cases, especially about this case? So any question? So should we conclude? So thank you, participants. Thank you very much, all of you.
Thank you, sir.
Thank you, sir.
Thank you. Welcome.
Are there any questions from the participants?
Will you sharing all the case laws we discussed today?
Yes, sir. I'll share the PPT, and thank you so much, Ashok Juneja, sir, for taking the session. It was very informative. Thank you for sparing time and taking the session. Thank you.
Welcome.
Thank you, sir. Thank you all.
Welcome. Thank you.